I'm Michael Hainsworth. Death and taxes are guaranteed, but relying on artificial intelligence to do the paperwork for the Grim Reaper is no guarantee of success, and it could leave your family in the lurch. Maybe you've got a blended family, a family business, a child with a disability, two siblings who remember the same parent very differently, a piece of jewelry that carries more emotional weight than financial value, a tax bill that no one saw coming. A digital will that looks clean on the screen will create confusion in court. Alyssa Mitha says it's better to have no will at all than one you don't understand. If there's one thing you want the listener to know based on this conversation, what should it be?
I'm not telling you to get your will done this week. I would say if you don't have a will done, I would think about meeting with someone to have it done. For those individuals that have their estate planning done, when's the last time you looked at it? Right? If it's been 5+ years, do you know where the original document is? I would review it and just make sure that it still matches your intention. And I would say from the AI perspective, meet with the lawyer first. Find someone you're comfortable with. AI should be a last resort.
It's a tool, it's not the solution.
Absolutely.
Alyssa Mitha has seen estate planning from both sides, as a lawyer helping families draft plans and through litigation when those plans fail, or when there was no plan at all. On this episode of On the Money, why estate planning needs to be more specialized, why what seems fair on paper is not always in practice, and why artificial intelligence may make estate planning look easier while making the risks harder to see. But first, when we last talked about the power of compounding, I pointed out that we have no interest in being old when we're young, but compounding isn't just about earning returns. It's about what happens when multiple forces stack on top of each other. Return on capital, return on invested income, return on rising contributions, even returns on better decision-making over time. And that's where it becomes powerful. So let's move beyond the basics. Let's start with shielding your assets from the tax man, because taxes and fees don't just subtract, they compound against you. I want high growth equities in my tax-free savings account. And if you're like me, and I know I am, you haven't maxed out your contributions. So let's now layer in contribution growth. If your income rises 3% a year and your savings remains flat, you're falling behind. Escalate your contributions, 5% more each year, 10 if you can. That creates a second compounding curve, one driven by behavior, not the markets. Think about reinvestment discipline, dividends, interest, distributions. If you don't reinvest them, compounding breaks down. If they stay in, the base grows, quietly but relentlessly. It's called a DRIP, a dividend reinvestment program. Instead of getting a check, your dividends automatically buy more of that stock instead. Most investors see volatility as a risk to compounding. Actually, markets can allow new capital to buy more in the future, but only if we keep investing. Compounding is not passive, it's engineered. When you align tax efficiency, rising contributions, disciplined reinvestment, and behavior through cycles, compounding stops being a concept and it becomes a system. Alyssa, AI is showing up everywhere. Estate planning is among them. What worries you the most?
AI is so accessible, right? It's cost efficient from an estate planning perspective. It's everywhere. There's ads all the time for these online will kits. And I think clients are always thinking about estate planning. They're thinking about drafting their wills. It's something on their to-do list. So when it's that accessible online, it's an easy click and they start working on it. But are they truly understanding what they're signing, right? It looks great. It's polished. It seems perfect, but is it actually truly meeting their intentions?
Right, it's got all the M-dashes that you could want, but is it really working for you? Give me an example of what kind of mistake an AI-generated will or online will kit could make.
Absolutely. So, a very simple example, a lot of clients who might want to do an equal distribution to their two kids. So child A, child B, each receiving 50% of the estate. But what happens if child A predeceases you? Do you want that share to go to their heirs, or do you want that share to go to the surviving child? Now, when I was in private practice, I would say majority of clients would want that share to go to the deceased child's heirs. Every client is different, but that will kit or that online platform might not give you the opportunity to choose. So clients aren't realizing that if child A was to predecease them, child B is now acquiring the entire estate.
Right. So if an AI isn't asking you enough questions, you don't even know what answers you need to be giving it in the first place. You mentioned that you've worked in private practice, so done both drafting as well as litigation. What does litigation teach you that drafting alone might not?
So drafting, you're meeting with the client, everything might seem great, right? So that example where you're leaving an estate that's 50-50. And so everything seems fine, right? Why would there be risk of litigation when you're leaving half of your estate to one child and half of the estate to the other child? But from a litigation lens, things are so different. And, I have so many stories, but one that really stands out to me is, we had clients that were receiving, $5 million each, right? After taxes were paid. And yet they went to litigation over a pair of $2 reading glasses, thousands and thousands of dollars in legal fees over something that had no value, right? And this is after the children have benefited such a significant amount from the estate, but yet there's reason to fight. So the litigation side shows you that even personal effects that might have no monetary value, but because they hold that emotional significance, can have an impact.
And what AI knows what's going on in your own head.
Absolutely. Yep. No clue, right?
So Alyssa reminds us that a will is not the plan. It's only one expression of the plan. Families change, assets change, health changes, and conflict often starts in the space between what someone meant and what they actually wrote down. So I want to move from the general to the specific. Family businesses, unequal tax treatment, the danger of thinking an estate is fair simply because the numbers look balanced on paper.
So, Alyssa, let's expand on the phrase equal on paper and why that can be misleading.
A lot of times, again, with a 50-50. So let's say you have a house worth $500,000 and you have investments worth $500,000, registered plans. You're deciding that you want to leave your house to the one child that's living in the home, and then the other child is going to get your RIF. Let's say we're in a situation where we know that the client's going to pass next week. Maybe they're doing some last minute planning because they don't have a will, and they're thinking that everything looks great, right? It looks equal. Well, where is the tax implication coming from? So those registered plans, that's going to be fully taxable income on death, and the estate is going to cover the tax bill. What's the estate asset? The house. So the house is now going to have to be liquidated to cover the tax bill. And now that child that was supposed to receive the house isn't receiving the house. They're receiving a much significantly less portion of the estate.
I like a family business example as well, because it seems to me that that's where complexities would substantially grow in any estate planning scenario. What goes wrong when, some children are involved in the business and others aren't, but you want to make it fair?
I would tell any client that has a business that they absolutely need to have a business succession plan in place. And we find that business owner clients are the ones that do it less. I think there's a stat that like 9 out of 10 business owners don't have a succession plan in place. And that is so problematic, especially when you're looking to, equalize the estate a little bit. If you decide to leave everything equally between your two kids, well, is there enough liquidity in the estate where the child wanting to take over those business assets can purchase the shares from the other child? There's so much more to think about. So in your mind, you have enough to leave everything equally 50-50, but then the tax implication comes in and there's this big tax drag taking out a bulk of the estate. Well, now how are you going to equalize things, right? So in a client's mind, things might look okay, but once you look at that tax implication and the planning, is it truly an equal distribution?
Yeah, I'm on Instagram doom scrolling and seeing all of these videos of cottages in Muskoka underwater. And it reminds me that, those are possessions that are getting passed down generation to generation. I can imagine the family cottage probably ends up being the bigger stress point in any estate planning than pretty much anything else.
Cottages are a big reason for estate litigation. They're expensive to maintain. And then once you have the next generation involved, more kids, spouses involved, everyone has an opinion, everyone has a say, people are earning, different incomes. So who's then going to be able to pay for those ongoing costs of the cottage? And that's something to think about early on.
You mentioned that everybody has an opinion. Should we be listening to those opinions when we're drawing up a will or developing estate planning? Or should we just be focused on what we, as the person who's doing that will, wants?
I think ultimately decision making comes from the client, and that's important. However, family governance and the value of family conversations is so important. And, when I was in private practice, I would encourage clients to have a conversation with their family, especially if you are making particular decisions that might create conflict. So I'll give you an example. Let's say you've benefited a child throughout their lifetime, right? So you've helped them make a down payment. You've helped cover costs for a wedding. Maybe they have, a few degrees and you've helped cover their education costs, and you haven't done that for another child. Well, you can put in language in your will to help equalize the estate, right? Or have that conversation. But a lot of clients will shy away from that. So they'll do an unequal distribution in the will. And there was good reason for it, but they haven't had that conversation. So the families don't know what's happening. And then individual passes away and now the will is read. And we see that there's this unequal distribution. So even though there was a very good reason for it, because we didn't have that family conversation and the kids weren't aware of why that planning took place, it's so problematic. And there's reason why we are creating issues in that family harmony. So I think opinions matter less, but having that family conversation is key.
When you and I were having a chat before this recording session, you brought up one that had never occurred to me and seemed incredibly complex, which is talking about planning for inheritors who have physical or mental health related disabilities. What are we not talking about that we should?
Yeah, I'm extremely passionate about this area only because I've seen things go terribly wrong. So if you have a loved one that has a disability and is receiving provincial social assistance benefits, right? So I live in Alberta, we have AISH, in Ontario, they have ODSP, BC has PWD. If you have a loved one that is receiving those benefits, if you were to leave them an inheritance outright, or if you don't have a will at all, meaning they die intestate and the provincial laws apply and they receive that inheritance outright, then they are at risk of losing those provincial social assistance benefits. That might be covering their living expenses, their prescription drugs, and a number of other benefits. So if you have a loved one who has a disability and is receiving those benefits, you need to get planning done and put a trust in place so that those benefits are protected, because otherwise they are at risk of losing everything.
The idea being that those benefits existed because that individual, that child of the person who's putting the will together, perhaps has a certain income or lack thereof themselves. But the moment that they get flush with cash from the deceased parent, that changes the dynamic. Is that how it works?
Yeah, so if you're receiving those benefits, there are certain asset and income thresholds for that province. And in each province, they vary a little bit. So if you're receiving that outright inheritance, you are very likely going over those income and asset thresholds. So there's a planning tool known as a Henson Trust that is able to help with that. So Henson comes from a 1989 Ontario Court of Appeal case, but essentially this Henson Trust is a fully discretionary trust. So the client would essentially appoint a trustee. It could be a loved one, it could be a trust company, and they are going to determine how much can be paid out to that beneficiary. So they have full unfettered discretion in determining how much can be paid out from the trust fund to the individual with a disability. And the idea is you're enhancing their life, but you're not going to kick them over those asset and income thresholds, or then those provincial social assistance benefits are at risk.
So trust funds aren't just for guys named Chad who wrap their sweaters around their necks?
Exactly. Yeah, you got it.
Alyssa is showing us why equal can be a trap that an AI might spring. A business left to one child and investments left to another may look fair until taxes, liquidity, control, and the timing enter the picture. And for families supporting a loved one with a disability, the wrong structure can put benefits at risk precisely when the protection matters most. So how do we get estate planning right?
Alyssa, most people think that estate planning means drafting a will, but it's actually only part of a larger plan.
So a will is one component of your estate plan, right? So I think a will does two things. Number one, it chooses a person who's going to administer your estate. So that could be an individual, a group of people, a trust company. And then the second aspect is obviously the division of your estate assets, which is important. And then in that can be, trust components and other things, but that's one piece. You have to remember your registered plans that have designated beneficiaries, your life insurance policies that have designated beneficiaries, those all fall outside of the estate. And then you also have your incapacity planning, right? So powers of attorney. And I can't tell you the number of clients that would come into the law firm and say, I'm going to get my will done. And then I would ask about powers of attorney. And they'd be like, oh, we don't need those right now. We'll get them later. And I think that the POAs are almost more important than the will. because the powers of attorney come into play while you're alive, but typically you become incapacitated, right? So who is going to make those financial and healthcare decisions for you while you're alive but incapacitated? And then for those clients that don't get them done and something happens, then it's often the kids who are looking to do a guardianship application so that they're able to become legally appointed guardians. But it's much more than that as well, right? You're looking at tax planning. You're looking at trust planning. So in provinces like Ontario and BC, where we have probate fees that are really high, we might look at setting up, some living trusts to be able to minimize those probate fees. And that's all part of a broader estate plan. And then you're also looking at the business succession side of things, right? And I encourage clients to meet with lawyers early because there might be things we can implement, like an estate freeze to help with taxes. And so there's a number of different tools in that kit, and a will is one piece out of this large puzzle.
When it comes to powers of attorney, what's your best advice as far as who that gets to be? It often ends up falling on the eldest child of the person doing the estate planning, but that's not necessarily the best person for the role.
Yeah, that's a great question. So, there's two types of powers of attorney. One of them deals with all of your financial decision making. I would appoint someone you fully trust and someone who's financially savvy. They're absolutely able to do anything with your money, right? So they can sell your house, they can go through your bank accounts, they can do all of those things. So appointing someone that you fully trust is so important. And then on the healthcare side of things, I would appoint someone who's going to make the same decisions as you, right? And so your kids might be different for the financial one and the healthcare one, but it's really important that you think about that. Now, for a will, when you appoint an executor, it's a joint appointment, right? So the decisions have to be made together and unanimously. For the powers of attorney, you get a little bit of flexibility. So you can do a joint appointment, meaning all decisions have to be made together. If something needs a signature, all the named individuals have to be there to sign. But you can also do what's called a joint and several appointment, meaning that they can act together or they can act independently. So if you have a child that travels a lot, maybe it's a better idea to do a joint and several appointment. That way the one child that's in town can just sign.
We've talked about a few professionals that one would have in their life to help them with the estate planning, the lawyer particularly, the family members who would be involved in those hard conversations as well. What role does your financial advisor play? Because as you point out, you want someone financially savvy, but not all of us are.
Yeah, the advisor plays a huge role. So remember, you have an ongoing relationship with your advisor. They know you pretty well. They typically know about your family situation. When you meet an estate planning lawyer, how often are you meeting them, right? You might meet them one time to get your planning done, maybe a couple of times if you're making some changes, but the advisor knows you well. So whenever I would meet with a client, I would encourage them to even have the advisor on the call because the advisor might let me know some information that they think is relevant and it leads to a better estate plan. The advisor is also asking questions in advance, right, to the client. So the client has some things to think about prior to meeting with the estate lawyer. So the advisor plays a huge role. And I know when I was in private practice, I personally loved when the advisor was involved.
So when an investor goes to their lawyer before drafting begins, they need to bring a clear list of assets and liabilities. But what else?
It's funny, we used to actually hand out an estate planning questionnaire. So it was about 10 pages. We would give it to the client in advance. And that way, when they come to the meeting, they would have known what to think about. And that didn't actually go very well. We found that clients were canceling appointments. And then one day I had a client come to me and say, don't hand out that questionnaire. She's like, I felt so overwhelmed. It was hours and hours of time. I didn't know what you were asking for. And we got through everything in a couple of hours. So my big thing is don't overthink it. I think it's important to bring in, like you said, a list of assets and liabilities. You want to be able to get advice on that. I would bring in your beneficiary designations so that we can confirm everything is accurate and it's the way that you want it to be and that we don't need to include that in the will. I would think about, who you want to appoint as your executor and that sort of thing. Be prepared and come in with questions, but I don't think you need to have a plan in place. Just think about, what you're looking to do, what your intentions are, and maybe different ways that we can craft it. But I don't think you need to have this big plan in advance.
Okay, so then what kinds of questions ought one to bring to an estate planning lawyer?
So anything particular in your family that you think you want to ask about. So let's say you have a loved one that maybe had addiction issues in the past. That's something that I would bring in and say, what are my options there, right? Maybe paying for your grandkids' education is important to you. come in with all of those sorts of examples so that the lawyer can let you know what your options are. So I think it's important to think about your family scenario and really know what you want. And then the lawyer is there to then provide you with the options, right? If you have two kids that don't get along really well, and maybe you're like, I should appoint them both as executor because it'll bring them together, they'll have something to work on, the lawyer's probably going to tell you that that's a terrible idea, right? Because if they don't get along now, they're probably not going to get along in the future. So I would really think about your family scenario and explain to the lawyer, this is what's going on. And that way the lawyer can give you options rather than you making those decisions prior to meeting with the lawyer.
Yeah, you want to have the hard conversations with the family before you walk in that door.
Yeah, governance is key, right? Having those conversations with the family, letting them know what you're thinking, asking them for permission if you're appointing them as executor, because you might think it's a great choice and it's an honor for them to be appointed, and they might see it totally differently.
So can an executor you want to execute your will turn it down? And if they do accept, what happens if they die?
If you don't want to act as executor, then what you should do in advance is sign a renunciation. You never want to take on the role and then decide later on that you don't want to act. And always have alternates named in your will, right? Because if someone is unable or unwilling to act, or like you mentioned, passes away, what's the backup plan, right? Who have you appointed? And I've seen a number of situations where no one has been appointed as a backup. And then it's problematic because we might be looking at a trust company, which can be a good option, but all the beneficiaries have to be agreeable. If you have beneficiaries that don't get along, it's hard to get that consensus, right? So pre-plan in advance, always have backups named. I would say 3 backups is a good plan.
You said something interesting before we started this recording. It may be better to have no will than a will you don't understand.
Yeah, and I still stand by that. I'm not encouraging anyone to not get their estate planning done or get their will done, but I think it's better that you go through those provincial rules where, they are making more of a fair decision rather than you signing a will that you think is meeting your intentions. And then it turns out you didn't fully understand it or there were things missing, right? And I think we see that with those will kits. They get them done, everything looks good. And then it's not until the client passes and an estate lawyer is reading it and saying, there's problems here, right?
So, we've been dumping on AI over the course of our time together. Is there any place for it in your line of work?
I think that AI can be useful in being able to give clients a better understanding of things that they should be thinking about and solutions. And those are all things that you might want to do before you meet with your lawyer, right? There are some lawyers that are going to charge an hourly rate. So I think it's good to always be educated prior to those appointments. I know people who have used online will kits and then have met with a lawyer to just go over them to ensure that it looks okay. So I think it has a place, but I think you have to be really careful. And ultimately, I think if you're going to sign something that was generated online, you need to meet with a lawyer to make sure that it still matches your intentions.
If there's one thing you want the listener to know based on this conversation, what should it be?
I'm not telling you to get your will done this week. I would say if you don't have a will done, I would think about meeting with someone to have it done. For those individuals that have their estate planning done, when's the last time you looked at it? Right? If it's been 5+ years, do you know where the original document is? I would review it and just make sure that it still matches your intention. And I would say from the AI perspective, meet with the lawyer first. Find someone you're comfortable with. AI should be a last resort.
It's a tool. It's not the solution.
Absolutely.
Thank you so much for your time and your insight.
Thank you, Michael.
Alyssa cautions that an AI-generated will may seem like an inexpensive solution to a problem that most of us don't want to deal with in the first place. As a way to flesh out some of the basics before sitting down with a professional or two, that's the place for AI. Speak to your financial advisor, speak to your legal advisor, and sit down with the family and have the hard conversation now before it's had after you're gone. Now you're on the money. I'm Michael Hainsworth. Thanks for joining us.